agreed that we would work together. I'd like to see us do this. So let's work together, and let's not try to micromanage an agency that is designed to be the cop on the beat.
All right, we're going to let Ms. Barbero open with her testimony, and I'd suggest maybe we send a joint letter requesting his appearance. So, with
if
that,
I may
Ms.
respond, you have addressed me. I will respond. Why not send a joint letter that we can agree upon, not a joint letter that is a take it or leave it? I yield back.
So with that, Ms. Barbero, you are recognized to give an oral presentation of your testimony, and without objection, your written statements will be made part of the record, so you are now recognized for 5 minutes for your oral remarks.
Good morning, Chair Huizenga, Ranking Member Green, and members of the committee. Thank you for inviting me to testify today. I note that my testimony is provided in my official capacity as the Commission's General Counsel, but does not necessarily represent the views of the Commission, the Commissioners, or other members of the staff. The Securities and Exchange Commission is an independent federal agency headed by a bipartisan 5-member commission and charged with a 3-part mission: protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. The agency's work is critical to the functioning of the U.S. and global economies, as well as the financial well-being of millions of American households. Since I started at the agency nearly 2 years ago, I have been in awe of the dedicated staff who show up every day ready to serve the public in pursuit of the agency's 3-part mission. Today, I have the privilege of appearing before you as the SEC's General Counsel, a position I have held since February of this year. As General Counsel, I am the agency's Chief Legal Officer, responsible for advising the Chair, the Commissioners, and staff throughout the agency on a variety of legal matters that touch all aspects of the SEC's activities. Serving as the SEC's General Counsel is a tremendous honor, and I am fortunate to be able to observe firsthand the incredible contributions of my office's nearly 150 talented and diverse employees. The staff has impressed me daily with their expertise, dedication to the mission, and incredible sense of camaraderie and teamwork. OGC is generally organized into 4 groups: our appellate group, the General Litigation Group, the Legal Policy Group, and Adjudication and Oversight. The Appellate Litigation Group represents the Commission in the federal courts of appeals, in certain bankruptcy matters, and in conjunction with the Solicitor General in the U.S. Supreme Court. The General Litigation Group provides legal advice to agency management on a broad range of issues and defends the Commission in civil and administrative litigation relating to the performance of the Commission's official functions. The Legal Policy Group provides legal and policy analysis and advice to the Commission and staff across the agency on enforcement and regulatory matters. Within the Adjudication and Oversight Group, the adjudication staff advises and assists the Commission in issuing opinions in administrative enforcement proceedings and appeals from decisions by self-regulatory organizations. The Oversight and Investigation staff advises and assists the Commission with a variety of functions, including responding to congressional correspondence and oversight inquiries. The dedicated oversight function is a recent addition to the office and reflects a decision by the agency to hire a specialized team of attorneys to improve the Commission's oversight response capabilities, among other things. I appreciate that I am here today because of this committee's interest in the Commission in the Commission's work responding to oversight inquiries. I am familiar with the Commission's recent inquiries, excuse me, and I want to assure you that my team and others are working diligently to respond to the committee's requests. We are committed to working with committee staff to provide the committee with information that it has requested. The creation of OGC's oversight team and the resources we've dedicated to it, including at the highest levels within OGC, reflect that commitment. I share Chair Gensler's great respect for this committee. Our work at the Commission is made better every day by input from individuals outside of our building, including investors, issuers, the entities we regulate, and this committee and its members. Thank you for the opportunity to testify today and for the committee's continued support of the SEC, its mission, and its people. I am happy to answer any questions you may have.
Gentlelady yields back. We are now going to turn to member questions, and the chair, myself, will recognize myself for 5 minutes. And Ms. Barbero, I want to dive right in. Is it true that the SEC employees in the Office of Intergovernmental and Legislative Affairs have prior experience in congressional oversight and investigations?
Thank you for the question. Just to clarify, that's not my office.
I understand, but
yeah,
do they?
Yes, that is
okay.
correct.
And is it true that the SEC employees in the Office of the General Counsel have prior experience in white-collar litigation and congressional investigations?
I think that question refers to the oversight function that we've recently stood up, and yes, they do have significant experience.
These aren't trick questions, it's just yes or no's. So it's safe to say the SEC has hired some good staff, right, who know the ins and outs of congressional oversight. Certainly yourself has been a longtime hand at this. Yet, frankly, we have not received substantive responses in most of our requests. And it seems like you and the rest of the SEC staff, who are well-versed in congressional oversight and our responsibilities, are very well equipped. We know you have great, stellar reputation for being a very, very good lawyer, a tough lawyer, and you know how to respond to congressional requests, because you certainly have put those out in your previous capacities. But some might suspect that the SEC is using your congressional oversight experience as a weapon to block us at every turn, frankly, and I sincerely hope that that is not true. But on February 10 of this year, we sent a request related to Sam Bankman-Fried's charges with a deadline of February 24. Are you familiar with that request?
I am familiar with that request.
So it's my understanding that your office does an initial assessment within 24 to 36 hours of first receiving a letter. Is that correct?
I don't know the exact timeline, but they are reviewed expeditiously as soon as we receive requests in our office.
We'll expand it to a generous 48, 24 to 48 hours. All right. So what day did your office begin to actually search for documents and communications responsive to our February 10 request?
So thank you for the question, because my office is committed to responding to that request and the committee's other outstanding requests, and we take all of those requests in.
Do you know what date you started and initiated?
I know that each request is reviewed expeditiously. I can say with respect to that particular request that staff engaged with your staff to understand the committee's priorities.
Hold on, it was not before the deadline. Because during the first conversation between committee staff and your office, which happened to be a week after the deadline, your staff was asking questions attempting to narrow the scope of the request in order to start a search for the documents. Are you familiar with the briefing the Division of Enforcement provided to the committee?
Yes, I am.
Okay.
We offered that.
All right.
briefing.
In your professional opinion, do you think a briefing about how the SEC and the Justice Department work together is sufficiently responsive to our request for records and communications?
So I thank you for the question.
You turned it off.
Thank you for the question. I do think that the briefing is responsive, and the reason is that the request looks at and is asking for information about a parallel investigation conducted by our staff at the SEC and the Department of Justice.
Okay, so am I supposed to now send all of our SEC inquiries to the Department of Justice?
Congressman, we have been responsive to your staff with respect to
That's
the
not my
documents.
question. So if you're telling me that, well, we can't answer anything, but we were slow to start, you seem to acknowledge that. We're now had to kick it over to DOJ. So are you familiar with the production your team made at the briefing on March 15? That's just a yes or no.
Is this the 232 pages of documents that staff
So, yes.
produced? Yes,
Yes.
I am.
All right. Do
familiar
you
with
think
that.
it's responsive or productive use of anyone's time to print public complaints and your own enforcement manual and treat it as if it's responsive to our request? Is
So-
that a good use of your very qualified, highly paid staff? Because
so
it's not of mine.
Many of the committee's requests, including the FTX requests, are broad and encompass not just
Okay,
internal
so
documents.
you're stalling now. Let's turn to the February 22 climate-related request. Are you familiar with that request? Yes or no?
Yes,
Yes,
I am
okay.
familiar.
The SEC produced 29,000 pages pulled straight from the public comment file. One of your productions even included a letter that I sent to the chair congratulating him on his chairmanship. Are you aware that to date, 80% of the documents in response to our climate request are publicly available? I'll let you answer and then time is up. So you are aware that 80% of it is publicly available?
As our rulemakings are conducted in the public view, they are very transparent. The documents produced are responsive to the requests, and we are working on
All
reviewing
right,
the
I'm going to
committee's
take that as a
internal
yes. And
priorities.
my time has, I'm going to try to be respectful of everybody's time. That was a stalled out yes. So with that, per tradition, the ranking member defers to his members. And so the gentlewoman from Texas, Mrs. Garcia, is now recognized for 5 minutes.
Thank you, and that's Ms. Garcia. Thank you for being here with us today, Ms. Barbero, and I want to first start by just giving you a chance to finish answering your question, the question that was asked about the March document request. You know, you're a lawyer, I'm a lawyer. I was used to a lot of getting interrogatories and document requests, and, I never was quite bombarded, and it wasn't a lawyer gone amok like this investigation oversight group seems to be going on amok with so many requests. Do you feel, is your statement here today that you did comply and were responsive to that March request?
So if I could just clarify the question, it's the February proposed climate request that Chair Huizenga had asked about, but that February request, I very much appreciate the opportunity to answer. We have been responsive. My staff has collected over 2.7 million documents internally from 53 different custodians in response to that request. They are in the process of working with committee staff to identify priorities and reviewing and producing on a rolling basis the internal documents that the committee staff have prioritized. So yes, I do believe we have been very responsive, and I have instructed staff to continue to work with the committee on that request.
Right. And it seems 2.7 million. I mean, that beats even some of the, major personal injury trials that occur all over this country. How long have you been in this position?
I have been the general counsel since February 1st.
February 1st. So have you ever seen this kind of constant and somewhat obtrusive document requests made by a congressional committee?
Well, we do have, in addition to the climate requests for which we've collected, and that's not pages of documents, just to be clear, that's number of documents, 2.7 million. We've collected on the order of 700,000 documents in response to the committee's request about digital assets. We've provided briefings, staff have answered interrogatories. We have certainly done everything we can do to be responsive and respect the committee's oversight priorities.
But can you explain some of the burdens the agency faces when responding to these document requests?
Well, when we get a document request, one of the first things that we have to do when we get the request is scoping interviews with agency personnel across the various divisions and offices in the agency to determine who might have information that's responsive to interrogatories or who may have responsive documents. So those interviews take time. We then need to collect the documents. When the documents are collected, they have to be reviewed by our staff and keyed up for production and then Part of the reason why the production to date has been public documents is those do not require a commission vote for us to turn them over, so we're able to more quickly provide responsive information in the public record, but we then need to tee up for the commission to vote to release internal records to the committee in response to the request. So it is a significant process and undertaking.
Right. So as the quote unquote, the cop on the beat, who is it within your organization that decides which needs referrals to the Justice Department? Is it you or someone from the commission?
It is our enforcement division generally that would be working with the Department of Justice on a parallel investigation and working in collecting information and facts and working with justice. That's the Division of Enforcement.
Yeah. Well, I for one want to thank you for the good work that you and Chair Gensler have done in enacting common sense regulations and policies despite this, investigation gone amok and despite this documentary regress gone amok, because I think it's important work that you're doing for consumers and investors. And I want to just ask you, is there anything we can do in Congress to further improve the work that you're doing at the SEC?
Well, thank you, Ms. Garcia, for your support, which is very much appreciated by me, and I feel comfortable saying on behalf of the chair and the commission, we really appreciate this committee's support and commitment to the agency, and I will just say thank you.
Thank you. And Mr. Chair, it looks like my time's run out. I yield back.
Ms. Garcia yields back. With that, Mr. Sessions from Texas is recognized.
Chairman, thank you very much. Council, welcome to the subcommittee. Is it true that you deal with civil litigation?
The SEC does handle civil, not criminal litigation.
Thank
yes.
you. The chairman evidently met with major Democratic donor Sam Bankman-Fried. Where was that meeting held?
I don't have any of the details relating to that meeting, but I'd be happy to get back to you with any information if there's specific questions that you have.
Thank you very much. As a matter of fact, I do have some. Council, I'd like to go to one of the basic tenets of why the SEC, their major tenets of what they're there for, and one of them is the formation of capital. And the concern I've got, and I'm going to speak here for a minute so that we're very clear, because I have said this to Chairman Gensler point blank in the General Committee, in the larger committee, that I believe that the SEC has weaponized their discretion that they use against the formation of capital. My father served as director of the FBI we used to have a president whose name was Reagan, and then a man named Bush, Herbert Walker Bush, and then a man named Bill Clinton. And when he first came to the FBI by and large had a operational way of doing business where they would investigate and go around people, and then at some point indict them. And it was very difficult for people who were under investigation to engage the Bureau for months and months. And my father, as a result of his service as U.S. Attorney to the Western District of Texas and Chief Judge of the Western District of Texas, attempted to and did change that policy. And that policy is one that I would like you as General Counsel. I've already tried to come to Chairman Gensler, and it fell on deaf ears. I believe that where there is someone who is under investigation, where you have requested documentation, that person, if they hire competent legal counsel, I believe that competent legal counsel should be able to work with the SEC on the most in-depth questions that could materialize. And instead what happens is the SEC comes and weaponizes themselves to come in and give no feedback, no information, just ask for information without regard for any filing, in millions of dollars of perhaps assets that they have up, and they use their discretion and they hide behind someone. And they hide behind this, their purity. Well, we are the SEC. Rather than allowing someone to engage them on a professional basis who's a member of the bar and a court could hold them accountable for their behavior. And I want you to know that I find it unprofessional and disingenuous that this administration would have a chairman of the SEC meet with a man, perhaps we're going to find out where he met with him, only to find out that personal access, and yet someone who has millions of dollars and who is being handled by that agency for a long period of time, for the chairman to tell me upon investigation, Congressman, we're not going to say anything. We have an average of 214 days before we generally engage someone, before we say something. That's just an average. And I find that very unprofessional, and I intend, and I've been trying to engage and will engage the law to say that whoever it is, if the SEC is going to go and investigate someone, they're entitled to what I believe is the Bill of Rights, to some bit of opportunity to have professional counsel to handle that and engage your agency. So I just want you to know, I find the answers that have come out of the SEC wholly unprofessional, and that the actions that they take are to hold people at bay rather than allowing them. If you get trouble, you ought to be able to get out. Thank you very much. I yield back my time.
Gentleman's time has expired. With that, the gentlewoman from Georgia, Ms. Williams, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. Barbero, for joining us today. I walked in and didn't expect it to be a hostile situation in here, so my apologies for some of the way that you're being questioned today. But I sit on this committee to make sure that the most marginalized people in our society have a champion when it comes to financial and economic policy in Congress. I'm here to make sure that my constituents have access to affordable housing and credit, that consumers are protected from predatory actors in financial markets, and to work towards closing the racial wealth gap, which unfortunately my home in Atlanta leads the nation in the racial wealth gap. The SEC's role in protecting investors is essential to this work because the financial system needs to work for everyone, no matter their zip code. So this is especially true in Atlanta, which boasts a vibrant culture of innovation, sustained economic growth, and leading academic institutions, all the landmarks and hallmarks of a thriving economy. But again, we still have a lot of work to do. And even when people in my district get a good job or start a business, we know that people of color are more likely to be targeted by financial scams or lack sound investment advice. And there needs to be a transparent, safe, and equitable environment for all people to invest in and grow their wealth, not just those who have access to an expensive financial advisor. And this is where the SEC comes in. Each part of the SEC's mission, protecting investors, ensuring fair, orderly, and efficient markets, and facilitating capital formation, help level the playing field for marginalized people who are looking to invest their hard-earned money. And each of these duties is a full-time job, and I'm sure you are well aware of that. We've seen time and time again that the majority of this committee is focused on slowing down the important work that the SEC is doing through excessive investigations and document requests. Ms. Barbero, the SEC has continued to comply, no matter how overreaching, and I understand that the Office of the General Counsel plays an important role in answering these requests, so thank you. But I worry that these excessive and overreaching requests are exposing my constituents to harm by taking precious time away from the other functions of your office, functions that are crucial to the SEC's core mission that I just mentioned. Ms. Barbero, can you expand on the role of the Adjudication and Oversight Group plays in the broader operation of your office and the SEC in general?
Thank you for the question. The Oversight and Adjudication Group within my office plays multiple functions and roles within the office. The Adjudication Group assists the Commission in decision-making and preparing its opinions. The Oversight and Investigations Group works closely with attorneys and staff across my office and the commission. Currently, that group is fairly fully engaged in responding to working with the committee to ensure that we can respond to the committee's various oversight requests. That is a new function. I'm very proud that we stood up that group and that we have very talented staff in the group to be able to respond quickly and efficiently to oversight requests. But I would also note, as you noted in your question, that the group works with lots of other attorneys and staff across our agency who perform in the ordinary course of their duties, rulemaking functions, enforcement functions, and legal policy work, and the oversight group does look to them for their substantive expertise in responding to interrogatories.
Sounds like y'all are doing a lot with this group, which leads me to my next question. How do large-scale investigations and document requests, even these very broadly overreaching ones from the majority of this committee, impact the group's ability to pursue those other functions that you just mentioned?
Well, we do try very hard to prioritize the work that the group is doing. So when the group and other staff across the agency are prioritizing responding to oversight requests, which very much is a priority for us right now, that does, that is time that otherwise would be spent on, rulemaking, enforcement, other functions. But we are committed to responding to the oversight requests, and staff is working very hard to do that.
Thank you. Proper congressional oversight is necessary to make sure that our government works for the American people. But I think that the time and resources used on these disruptive and overreaching requests would be better spent maintaining a safe and fair financial environment for our constituents so that we can all thrive. Thank you, and I yield back the balance of my time.
Gentlelady's time has expired. The gentleman from Tennessee, the vice chairman of this committee, Mr. Rose, is now recognized for 5 minutes.
Thank you, Chairman Huizenga, for holding the hearing, and Ms. Barbera, thank you for being with us this morning. Ms. Barbera, as Chairman Huizenga mentioned, the SEC has produced thousands of pages of non-substantive documents to the committee, and a portion of those documents were previously produced under the Freedom of Information Act to other individuals. So, Ms. Barbera, the Commission has rules that allow the release of non-public information to FOIA requesters, correct?
That is done through a delegated authority, so it is the Commission's authority that is delegated to principally the FOIA office and the head of the
And
FOIA
so, yes,
office.
they can you can release non-public information.
Through a commission action on delegated authority, the FOIA, assuming that all of the legal requirements for FOIA are satisfied, yes.
Okay. Isn't it true that the Commission's FOIA rules do not require a Commission vote prior to the release of each set of non-public information to every FOIA requester?
That is true, but the reason it's true is because the way the Commission has structured its delegation of authority under FOIA, assuming the requirements of FOIA are met, the FOIA office is authorized by the Commission to handle those requests and produce those documents.
So isn't it true that the Commission's rules allow the chair to authorize the Office of General Counsel or the Office of Legislative Affairs to send an action memo asking the Commission to approve the release of responsive, non-public information to the committee on a rolling basis?
That is both true and where we are going in terms of responding on a rolling basis. So the committee has prioritized internal emails. Those would go through an action memo to a vote of the Commission for production to the committee on a rolling basis.
So given that that's
yes.
true, why hasn't the Office of General Counsel or the Office of Legislative Affairs started that process?
We in fact have started that process. We worked closely with staff on the committee to understand the committee's priorities. I understand those priorities are 13,000 DERA emails. That's our Division of Economic and Risk Analysis. The dedicated oversight.
So just to clarify, you have proactively asked for permission from the commission to start releasing that non-public information on a rolling basis. You've initiated that process.
Oh, thank you for the opportunity to clarify. That is the end of the process. We have to collect the emails, review the emails in order to advise the commission about voting to release those documents. So that process is ongoing, and we will continue to work with committee staff as we are making those productions to continue to understand the priorities. Of course, I can't sitting here commit to what the commission will do or vote when that goes up to them. I only have control over our part of the process within the Office of General Counsel, but yes, that is the process.
So you're saying that you're having to look at the emails before you ask proactively to the commission to authorize a release on a rolling basis? So you're going to have to assess every one of these documents before you ask the commission proactively. Only after you've reviewed all the documents would you seek their proactive approval or their prior approval for you to release documents as you come to them.
So I thank you for the question, and my role as the General Counsel, of course, is to provide all 5 of our commissioners with my best legal advice and the legal advice of my office. And so we do that through gathering the facts, understanding the facts, and then advising the commission.
But I think so we see that FOIA requests get blanket approval, but not Congress?
So I understand the distinction between FOIA and the oversight request. For the FOIA office to release documents, the statutory requirements under FOIA have to be satisfied. It is a delegation of authority to the FOIA office. It has, in fact, allowed us to produce documents to this committee that otherwise would be non-public documents.
And as we've seen, you're giving us documents that have already been produced publicly. So I would just strongly encourage you that in your next meeting with Chair Gensler, that you get him to approve the release of non-public responsive information to the committee on a rolling basis. And he should know that what the SEC has provided to the committee so far is not enough.
Gentleman's
and I would
time has
ask that we
expired.
put in the record a memo from 2001, 2002.
The memo from 2001, 2002 without objection.
Thank you.
So moved. With that, the ranking member of the committee, the gentlewoman from California, Ms. Waters, is recognized for 5 minutes.
Thank you very much. Ms. Barbero, there has been an ongoing and extensive comment period for the SEC's proposed climate-related disclosure rule, which would require U.S. publicly traded companies to disclose annually how their businesses are assessing, measuring, and managing climate-related risk. This rule would include disclosing greenhouse gas emissions as a measure of exposure to climate-related risk. Has the SEC received comments or other indications that the climate information the proposed rule would require be disclosed is in fact materially important for making investment decisions in a company? If so, would you please identify what those comments are?
Thank you. We've received a record number of comments in response to the climate proposal. And any number of those comments are supportive of the proposal and the disclosure of greenhouse gas emissions. In terms of specific comments and what specific commenters have raised, we'd be happy to get back to you if there's a question on that we could answer, but we have, again, received a record number of comments. Staff are actively reviewing and processing those comments as we move forward to any final rule that would be adopted by the Commission on the climate risk disclosures.
Thank you. I think that clarifies my question. Let me move on, Ms. Barbero. As you know, last Congress, I initiated a bipartisan investigation into the collapse of FTX, which Chair McHenry has continued in this Congress. It is my understanding that the SEC is concerned that some of the materials requested by the committee Republicans would prejudice the parallel ongoing criminal prosecutions as well as its civil enforcement action of Sam Bankman-Fried and possibly other FTX employees. I recognize that there's a delicate balance between providing Congress the information it needs and being careful not to negatively impact any ongoing investigation or enforcement action. I believe the members of this committee are sensitive to that potential problem and want to seek a resolution that accommodates both the concerns of the executive branch and the information needed by Congress. Therefore, it is important for us to understand what efforts are being made by the SEC to provide as much information as possible to Congress without creating a problem for executive branch enforcement actions. Please tell us, how is the SEC balancing the legitimate enforcement concerns with its obligation to provide Congress with information? And when do you expect to resolve this matter?
I thank you for the question, and that is very much what we have endeavored to do in terms of providing the committee with the information that it needs and balancing the important interests that we and I assume the Department of Justice have in not releasing information that could prejudice the criminal trial, which is scheduled to begin in just a few short months in October. We've worked closely with the committee to provide a briefing by experienced staff from the Division of Enforcement on how we work with DOJ in parallel investigations. We've provided a timeline on the FTX matter. We've provided the documents that we could publicly. The challenge here in balancing the concerns is that committee staff has identified as the priority the Commission's action memo, which is the very document that contains the information that could prejudice our civil enforcement action and the parallel criminal investigation. And that really is the challenge, but I would certainly invite the committee to reach out to DOJ directly. They have equities as well in the criminal case and have their own information as well. And so I think that's an avenue that could be pursued.
Well, I'd like you to continue with your work as you have defined it. I'm concerned that some of the Republicans are basically following the leadership of the past president of the United States. They want to defund the Department of Justice. So I want you not to be concerned about what you know you must do and how you must do it. And I yield back the balance of my time.
Gentlelady's time has expired. With that, the gentleman from Pennsylvania, Mr. Muser, is recognized for 5 minutes.
I want to thank the chairman very much. Thank you, Ms. Barbero. I think we should all be able to agree that just because an agency is run and directed by Democrats appointed by the Biden administration doesn't automatically mean they're doing a wonderful job. As a matter of fact, that's the whole reason for the Oversight and Investigation Committee. Ms. Barbero, unfortunately, the circumstances that lead to your appearance today are troubling. Chairman Gensler has shown a pattern of incomplete responses that is completely unaccessible. The SEC's interaction with my office over the last few months exemplify this. In March of this year, I was made aware of issues surrounding a merger between a certain SPAC and its target company. On March 28th, a letter was sent requesting a briefing. We had that briefing. On April 21st, 24 days after the initial request, the SEC did in fact meet with us. Briefing was helpful. However, there were many questions that went unanswered. On April 24th, my staff emailed the SEC requesting written response for these specific questions. On the 26th, a confirmation was made, and they requested a formal letter, which was sent on that day. The letter requests the SEC provide a response by May 5th. On May 8th, the SEC said it was finalizing the letter and would expect a completion on May 12th. On May 12th, we were informed that it will be next week. The following week, May 23rd, I asked for a call with the Office of Legislative Affairs, the SEC. There was a serious delay happening, God knows what. I received, finally on May 27th, a response that very general, only raised more questions. On June 1st, I personally sent an email to the SEC staff. On June 13th, my staff sent follow-up questions. And again, to this day, we have yet to receive a response from your agency to these questions. Can you appreciate why I'm a little bit critical and a little bit dubious as to whether or not you're even attempting to handle this particular request properly?
Thank you, Congressman, for the question. I am aware of the back and forth that you referenced and the timeline. If there are specific questions that I am able to answer, I can do that, or we can get back to you with information.
I'll ask a couple of specific questions. On average, an S4 review takes 130 days. Prior to you folks being there, it was 100 days. Would you say that 401 days is a little long, a little bit of an outlier, a little unusual, a little special, maybe deliberately special, deliberately targeted?
So in terms of the S4 process, I know there has been a significant increase. Your question referenced an increase in the average number of days. I know there has been an increase in the number of S4 forms filed that has contributed, I understand, in part to that increase.
Respectfully, 401 days, average is 130. You are aware that that length of time can kill the SPAC, and SPACs are owned by millions of individual investors. They will lose their money because you refuse to have any review or response, yay or nay, on a standard S4 application. 401 days. And here's a little bit of data to help out. In 2021, there were 11 over 340 days. That's when I asked for these questions 60 days ago. 11 out of over 1,000. In 2022, there's one, only one, that was over 340 days out of over 1,000. Okay, now it's 401 days with no response. You think that's reasonable?
And I understand that our director of the Division of Corporation Finance and the division, our enforcement division, have provided some of that information.
I'm sorry, ma'am. What does a citizen need to do to get a response to a standard question that should be run-of-the-mill SOP for you?
So there are any number of reasons why review of an S4 may take longer than average in any particular case. I can't talk about a specific review or a specific issue
I'm going to have to follow up again, and maybe I can get an answer. I'm going to yield the remainder of my time to the chairman. I yield.
Well, gentlemen, I appreciate that. I want to revisit where Mr. Rose was going and follow up. Are you aware that your staff has informed committee staff that it will take 10 weeks to review an initial tranche of documents that are responsive to a single question? By the way, that was narrowed down. That's out of 13. That even then they will not be ready to produce it to the committee.
I don't know the specifics, but I do know that the
10 weeks.
review depends on the number of documents.
10
and
weeks.
If this
Okay.
is,
Are you aware that previously the commission and the chair did not have to review or vote on every single document released, but rather gave blanket authority, much like the FOIA that you aptly described, to committee staff to provide necessary documents?
I am aware that there
You are
could
aware of that.
be other models
Okay.
of providing authority.
The time has expired. Excuse me, I do want to submit for the record an additional action memo that dates back to the Enron era, where it shows that there was this blanket authority given to release information to a congressional inquiry, and I'll submit that for the record without objection.
No objection.
With that, the ranking member of the subcommittee, a gentleman from Texas, Mr. Green, is recognized for 5 minutes.
Thank you, Mr. Chairman. Madam Consul General, would you explain to us whether you have a committee that sends you a request or whether you have many members who are sending a request?
We receive requests sometimes from members, but the requests we have been discussing today have come from the committee, the majority of the committee.
And you do have members who will ask for information as well?
That does sometimes occur, yes.
And have you tried as best as you can with the resources you have, and they are many, I confess, to satiate the desires of the members of the committee who are asking for information?
We are very committed to providing the committee with the information that it needs. We respect the committee's oversight priorities and oversight interests, and I am really proud of my staff who have worked tirelessly to respond to the committee's and requests.
Let me move to another subject, and if time permits, I'll come back to this. But in 2003, investors and banks with $136 trillion in assets under management have requested thousands of companies to disclose climate-related information for their investing and financing decisions. I have colleagues, my Republican colleagues, many, claim that climate-related information is not material to investors. Why is disclosure of climate-related information material to investors, Madam Counsel General?
So our disclosure rules at the SEC are aimed at providing investors with the information that they need to make informed investment and voting decisions. That information, it can change over time. It often does. It relates to developments in the market, to risks that companies are facing and our registrants are facing. And as we have heard from investors, many companies are providing information about climate-related risks, but we don't currently have that information in a comparable form that is useful to investors. That's what we've heard from investors. And climate-related risk can be just as important to businesses, to the nature and health of the business, as other things we might traditionally think about, like physical assets or material contracts. And the climate-related risk disclosure proposal that's out there walks through in detail the reasons why the Commission voted the proposal and believes that the disclosures are necessary to the protection of investors and the public interest.
Is it safe to say that it's about investor protection, Madam Counsel General?
It is about investor protection. That is a core piece of our mission and a core piece of our disclosure requirements.
And to this end, do you make every effort to acquire this intelligence so that you can share it with these investors who are going to suffer as a result of climate change, whether my colleagues believe that it exists or not?
So we have received, as I mentioned earlier in my testimony, a record number of comments from members of the investing public, issuers, other interested members of the public on our climate rule, and we are taking all of those comments into account as we think about, and the staff prepares recommendations for the Commission on how to move forward with any finalization of the climate rule.
Earlier, when you gave your testimony, you indicated that there was some large number of documents. Would you repeat that number for the record, please?
So in response to this committee's request to the Commission, my staff have collected 3.3 million documents, and as I mentioned earlier, that's not pages of documents, that's 3.3 million documents.
I would leave you with, this is not oversight, this is overreach run amok. Thank you. I yield back.
Gentleman yields back. With that, the gentlewoman from Missouri, the chair of the Capital Markets Subcommittee, Ms. Wagner, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Barbaro, what is your role in drafting responses to congressional inquiries?
I oversee the staff in the Office of General Counsel that works on oversight and investigations. That staff works closely with OLEA, our office that handles interactions with the Hill.
How big is your staff?
I have about 150.
150. Yes or no? Do you have final approval of the SEC's responses to letters from members of Congress?
I would have final.
Yes or no?
I wish I could answer yes or no, but it depends whether the letter is coming from me under my signature or whether it's a letter that's coming from.
Who has the final approval?
If the chair is sending a response, it would be Chair Gensler who would have approval. If his staff is sending responses or another officer is sending a response.
Thank you, Ms. Barbaro. What factors do you consider when deciding to simply submit our letters to the comment file of rulemaking instead of providing substantive responses?
So in responding to the committee's request, the staff correctly prioritized information that we could produce quickly and that was responsive to the request. That information, because our rulemakings are conducted in the public view in a transparent fashion, the comment file is in fact the record that the commission considers in finalizing the rule. So for inquiries about the climate rule, that administrative record, that is the key information that the commission is considering in deciding how to finalize the rule.
Thank you, Ms. Barbaro. Many of the letters my colleagues and I have sent to the SEC include very specific questions, but receive very generic responses. Are there internal policies or regulations that dictate how the SEC can respond to these letters? And if not, how is that determination made and by whom?
A lot of thought goes into how to respond to those. My staff will consult with subject matter experts across the agency.
They're very generic responses. I mean, one to Mr. Huizenga was one paragraph long. Please, proceed.
I don't know offhand the particular response to Mr. Huizenga. It depends on which. I had in mind our responses to the 7 interrogatories, which are quite detailed, are done and prepared in consultation with subject matter experts across the commission.
Let me, Ms. Barbaro, what is a reasonable time frame for your office to respond to congressional correspondence?
We engage with the committee right away when we receive correspondence.
Reasonable time frame.
The reasonable time frame is to engage, and if you are
Days, months.
So I know that this answer may not give you comfort, but it does depend on what the congressional inquiry
let me
is
move on.
and what the.
Chairman McHenry and I sent a letter on April 13th regarding the SEC's failure to focus on capital formation in its rulemaking agenda. In that letter, we included a response deadline of April 27th. The SEC responded to our letter just 2 days before you testify here on June 20th. The letter from the chairman of the full committee included 6 questions, none of which were answered. What is it about this particular letter that took you 2 months to answer?
Well, as is the case with all of the letters we receive, there is a process. What we are aiming to do in getting back to the committee is ensuring that we can provide accurate information, that we've consulted with the appropriate experts
You didn't answer the
in
questions.
commission.
You didn't accurate information. As I said, generic responses. You don't answer the questions. And I have to say, Ms. Barbaro, it was very disappointing to receive your 1-paragraph response to the letter Mr. Huizenga and I sent on April 17th regarding the legal authority for the SEC's regulatory agenda. 1 paragraph. You're telling me you're doing this in-depth study and this work, and you've got 150 lawyers, and this is the kind of response we receive. It is wholly, wholly inadequate. And I yield back, Mr. Chairman.
Gentlelady's time has expired. So I do appreciate the witness being here today, and without objection, all members will have 5 legislative days within which to submit additional written questions for the witness. Those will go to the chair, and I will be forwarding those to the witness. We ask our witness to please be responsive and be as prompt as possible to those questions. And with that, the hearing is adjourned.
The committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Oversight of the Securities and Exchange Commission, Wall Street's Cop on the Block. I now recognize myself for 4 minutes to give an